The NDC went to court earlier asking the court to put a stop to the Electoral Commission's decision to compile an entirely new electoral roll for the 2020 general election. In the same suit, the NDC was asking the court to also take steps to let the Electoral Commission make the existing voter ID card a requirement, one of the mandatory requirements for proof of identity for the purposes of registration in the 30th June voter registration exercise. The court had guided the party into withdrawing the first relief, which had to do with questioning the power of the Electoral Commission to compile a new voters register more than once. Subsequent to that particular withdrawal of the relief by the NDC, we had a private citizen also going back to the Supreme Court, asking the court to take back that particular relief in a fresh writ that he had filed. He's also arguing that the Electoral Commission, like the NDC had reasoned earlier, cannot compile the electoral roll more than once. The Supreme Court, upon taking a look at the case filed by Mr. Techibansen, came to the conclusion that the two cases have a bearing, and so they needed to link them, join them, merge them. But going beyond that, the court directed the lawyers of Mr. Techibansen to ensure that they file their statement of claim by Monday, noon on Monday. After this is done, the following day, on Tuesday, the other parties are supposed to also file their responses to the statement that the lawyer for Mr. Techibansen would have filed by Monday. Initially, the court was supposed to pronounce judgment on the 23rd of this month as to whether or not the Electoral Commission, excluding the existing voter ID card as proof of identity for purposes of registration, was on the right path. That has been adjourned indefinitely until the court is able to hear the two cases together.